all persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-5237. EB5 Holdings Inc. et al. Appellants versus Joseph Edlow, Director, United States Citizenship and Immigration Services. Mr. Bennett for the appellants, Ms. McDade for the appellate.
Mr. Bennett, good morning.
Good morning, Your Honors, and may it please the court. My name is Brad Bannis. I represent the appellants in this case. In 2022, Congress reauthorized the EB5 Regional Center Program, and it created an annual fee. It applied that fee to, quote, each regional center designated under subparagraph E, end quote, of that new law. USCIS quickly interpreted that to apply to all regional centers, like my clients who have existed as regional centers since 2014 and 2015. By interpreting each to mean all, both USCIS and the lower court created reversible error, and this court should reverse the lower court's decision and remand with instructions to enter judgment in favor of the appellants. This case comes down to a basic statutory interpretation. What does each regional center designated under subparagraph E actually mean? And we would suggest that it ends at the plain text. Each, meaning singular, specific, regional center, designated under, that would mean approved pursuant to subparagraph E, which is the statute that came out in 2022. Our clients, there's no dispute, were designated under the law that was originally created in 1992. The language of designation was added in 2002 and 2003. So they were designated by the Department of Homeland Security under that law, not subparagraph E of 2022 law that came out after they had been designated.
Wasn't that law repealed?
Your Honor, it was repealed and relocated is how the Bering Court in the Northern District of California rephrases it. And I would suggest that it was reauthorized. This statute has a 30-year history of reauthorization. The 1992 Regional Center statute was actually passed as part of an appropriations bill.
But if the legacy regional centers are still, viable or still, valid regional centers, then don't they have to be effectively or implicitly designated under E?
No, Your Honor.
Because that's the only way you can be a designated regional center.
I think that
under the current law.
I think there's a distinction between authorized and designated. I would suggest that subparagraph E certainly authorizes the program, but they were designated under a prior law. And that designation, there's no dispute. That designation was in place before 2022, at the moment of passage of 2022, and after 2022.
So if we were to agree with you, though, we would create a circuit split with the 11th Circuit.
Your Honor, it's an interesting.
Is there a way to distinguish the 11th Circuit's decision?
Your Honor, the 11th Circuit's interpretation, I think, violates a lot of canons of statutory interpretation. There's also an interesting question that all of these decisions related to EB5 are made here in the district. And so this court's decision would effectively bind USCIS because all of these are made at the thing called the Immigrant Investor Program Office, which is up on M Street, not too far from here. And so anyone who was aggrieved could come to this district and sue because that's where the decisions are being made. I just think the 11th Circuit decision, which is another one of my cases, Your Honor, they avoid the most clear statutory interpretation techniques that have been time tested, and that is disparate words mean disparate things. And somehow interpreting each regional center to mean all regional centers simply doesn't pass the first canon of statutory interpretation. I think they got caught up a lot, Your Honor, on why. Why would this policy make any sense? And my initial claim would be that the court's not supposed to look at policy. It's supposed to look at the statute. But I do want to answer that question.
And look at purpose, however.
Purpose. Yes, Your Honor. I'm sorry, Judge Rogers. I do think that it's pretty clear that nothing in this statute requires my clients to get, quote, redesignated. They were designated before, they remain designated. And this isn't apparent from the statute, but there are a lot of regional centers, including ones that my client owns, who are dormant now. That is, they got designated in the 2010s, they brought in investors, they finished the deal, and they're not seeking to pursue any more benefits under this statute. They are waiting for visa numbers to become available, and essentially the projects, the new commercial enterprises, have fulfilled their purpose and they're done. They're not out pursuing new investors. They're not out there being active. And so they were designated under the prior law. They are not required to seek designation under the new law. And so they should not have to pay for this fee if they're not participating in the program.
Do you attribute any significance to the fact that Congress acted by way of an appropriation?
I do not, Your Honor.
With a sunset date?
Your Honor, this program's always had a sunset date since
So
1992.
the clients were designated until the date set in the statute, right? In the Appropriations Act.
Your Honor, the sunset date goes to the authorization of the program, not the designation of the particular business that's acting as a regional center.
I don't want to play word games here, but you responded to Judge Henderson's question by saying that the statute was repealed, and you said relocated. And since we can look at the plain text of the statute and the purpose, the notion that Congress acted to get rid of graft and corruption, among other things, suggests that it wanted to start the program anew. There's nothing to suggest that Congress intended the graft and corruption to continue.
I agree, Your Honor. And we're not I don't think our position would further graft and
I don't know how
corruption.
Congress can do anything under your interpretation. Once you're designated, even hypothetically, were you representing a center that's been shown to be involved in graft and corruption? There's nothing Congress could do.
Your Honor, there are other provisions where they can be terminated. The designation can be terminated, and we're not disputing that. And
So you don't think that when Congress authorizes a center until fiscal year whatever, that at that time the authorization expires by operation of law?
no, Your Honor,
Why not? Isn't that what Congress does every day?
Your Honor, the sunset dates go to the authorization for the program. That
I
is,
understand that. So if there's no program,
well, Your Honor, for 30 years,
because there've been these appropriation acts. I mean, Congress could have acted a different way, but it didn't.
that's right. Congress did.
And so there is some significance that the court can attribute to the fact that it acts by appropriation act with sunset dates, as opposed to enacting a permanent piece of legislation. Is that correct?
If there is, Your Honor, I don't think it impacts this question.
If there is, it certainly does. That's what I'm trying to get. Your notion is that once you're designated for life. And it's up to the centers whether they want to operate and whether they want to attract investors or not. And there's nothing Congress can do about it.
Your Honor, the agency's never interpreted lapses in authorization to lead to de-designation. If that footnote
If that's true, then did Congress waste its time when it enacted when Senator Grassley and Senator Leahy got together on this reform bill?
I don't think it wasted its time. No, Your Honor, it reauthorized the program and it codified a lot of practices that were already in the regulations related to integrity measures. And it still, Congress chose to use different words to mean different things.
So your clients don't want to pay the fee that's designed to fund the things Congress thought were necessary to eliminate graft and corruption.
My clients who are not pursuing any benefits under the new statute do not think that Congress wants them to pay the fee. That's correct. My dormant regional centers that are simply waiting for visa numbers to become available for their investors who are making no money, who are taking in no funds. The project is completely done and they are pursuing no additional investors under this measure. So they cannot.
Tomorrow they could.
And if they
Under
want,
your argument.
Your Honor, and if that's correct. And if they did, they would likely seek redesignation and fall under this paragraph.
Why? You say they have. They've been designated and their designation has not been, repealed?
Because it's a marketing thing, Your Honor. This is a competitive market, and to go and sell to investors, you have to show you have a new designation.
So you're saying though, for the dormant centers that you would be seeking reauthorization if they were to become active.
Your
So
Honor,
then why not just allow the designation to terminate and not pay the fee, right? So failure to pay the fee will result in termination, of the designation.
because then the investors won't get their visas. And it'll lead to liability concerns and everyone will get sued and we'll be right back
But
here.
then your position is that while they're not actively investing, they shouldn't have to pay the fee. But that's not reflected anywhere in the statute. If a regional center wants to benefit from its designation for marketing or any other purpose, then it pays the fee.
Your Honor, this doesn't require anyone to get redesignated. We've been designated. We've stopped.
But you just said in response to Judge Rogers that if you were to become active again, that you would probably seek designation under subparagraph E.
And I think that's consistent with congressional intent. If you want to participate, you pay the fee. If you don't want to participate, you've been previously designated, you don't fall into the fee. And that's why it's each regional center designated under subparagraph E, not all regional centers in existence. Thank you, Your Honor. I'm happy to answer any other questions, but I see I'm over my time.
All right,
Thank you, Your Honor.
Ms. McTagg. Wait.
May it please the court, Alexandra McTagg for the government. This court should affirm the district court's decision, which is consistent with a recent decision from the 11th Circuit, that the integrity fund fee of the Reform and Integrity Act applies to all regional centers, not just those designated after the law took effect. The RIA was designed to curb fraud and abuse in the regional center program, which was rampant. It repealed the prior law, enacted the new law, and imposed certain reform and integrity measures. And those measures were to be funded by the integrity fee that applies to each regional center. Before the court is a question of statutory interpretation. What does it mean for the integrity fund fee of subparagraph J to apply to each regional center designated under subparagraph E? The government contends that based on the language, structure, and purpose of the statute, it applies to all of the regional centers in the program, whereas you heard the appellants contend that it only applies to new regional centers designated after the law took effect. But the district court agreed with the government, as did the 11th Circuit in Sunshine State v. USCIS. The fee provision in subparagraph J sets forth two fees that apply to each regional center. One, a lesser fee for smaller regional centers of $10,000, $20,000 for their larger regional centers. Now, appellants contend that there is meaning in the word each, but looking at subparagraph J, what that says is that the fee, the particular fee, applies to each regional center. It's not $10,000 for the aggregate of the regional center. So it's really just a grammatical way to indicate that it is an individual fee per regional center. But what's important in subparagraph J is that there's no specific clear language exempting legacy regional centers, and there's no time constraint on when this particular designation had to occur.
Let me ask you about the word legacy. They're not anything. I mean, it's a misnomer. Once it was repealed, they didn't get any sort of a legacy status?
So the law doesn't have any legacy term. And it's a shorthand that we've been using to indicate regional centers that existed before the 2022 law and regional centers that existed after. The Bering Court said that the regional centers from the prior law continued in the new law. And as part of that case and a settlement, USCIS agreed to continue that designation through. So the position of the government is that based on the Bering decision, the regional centers that were designated under the prior law continued as part of the new law. The old law was repealed and relocated into 1153B5, and the designation, the prior designation continued under that law under subparagraph E. And so there's no specific exemption for these so-called legacy regional centers. There's no limitation on the time period of when this designation occurs. And appellant's argument is facially appealing. They couldn't have been designated under subparagraph E because it didn't exist when they were designated. And so based on that, it might appear that subparagraph E is a method to designate regional centers, but it's not. Subparagraph E is the regional center program. That is where Congress relocated it after it repealed the prior law. And you can tell that from the overall structure of the statute. Subparagraph E is titled Regional Center Program, and the district court correctly held that it is comprehensive in scope. And for example, it talks about applications to become a regional center and the record-keeping requirements.
And there's this provision about not being a convicted felon. That's new also, isn't it?
It is. There are certain, under subparagraph H, there are certain requirements for the individuals involved in the regional center, including that they can't have been engaged in certain drug trafficking crimes or have ties to foreign governments or have engaged in espionage. And those types of reporting requirements are contained within the statute and have to be part of the annual reports that are submitted under subparagraph G. And so in looking at subparagraph J refers back to subparagraph E. Subparagraph E, Romanet 1, talks about regional centers, which has been designated by the Secretary of Homeland Security. And as the 11th Circuit held, has been designated has no set time period. So the designation under subparagraph E and the fee under subparagraph J, in neither place did Congress impose some sort of time period on when that designation had to occur. Now, there are places in the statute where it talks about new regional centers, and that would be subparagraph E, Romanet 3, which is the establishment of a regional center. That shows how to create a regional center after the new law was enacted. And as the district court and the 11th Circuit both held, if Congress had wanted to limit the fee to only those regional centers that were new, it could have done so by referring to paragraph E, Romanet 3, but it didn't. There were any number of ways Congress could have limited the fee provision to only new regional centers, and it just didn't do that. And so the government's position is it's clear from the face of that language that it's not so limited. It applies to regional centers that are designated under the law.
Well, I mean, under USCIS's original position, all regional centers would have had to be redesignated. And it was only after the Bering settlement that legacy regional centers were allowed not to be redesignated under subparagraph E.
Correct.
Right.
And so the government's position is that in accordance with that, the designation carried forward. And designation was a concept that was in the 2002 law. 2002 said the pilot program, quote, shall involve a regional center designated by the Attorney General on the basis of a general proposal. And that language is very similar to what carried through to the 2022 law, which said the regional center has been designated by the Secretary of Homeland Security.
So help me just understand the practicality of what's happening. I have a regional center. I was designated under the old law. I made my investments, I did my work, and now I'm dormant, and I'm just sitting there. What am I in fact, what benefit am I getting from my designation under those circumstances?
So the designation allows them to continue in the regional center program, which means, one, they could invest in new enterprises if they so chose.
Is that a decision they can make independently? In other words, I have a center, it's dormant. And by center, I have in mind a physical structure, not simply a computer program. So it's empty. It's just sitting there. And I'm probably paying property taxes on it. But I'm not doing anything with it that's relevant to the program. I'm not getting investments. I'm not bringing non-citizens into the country with the idea that become lawful. So I have this building that's empty. And the fee is to, put very generally, avoid graft and corruption and all these new requirements. But how does that have anything to do with my empty structure? And counsel tells us that, well, if they were to get new investments or be interested in getting new investments or bringing non-citizens to the country, they would get redesignated.
Well, Your Honor, they're still continuing so that their investors can file their petitions and ultimately get their visas, right? So they don't want to close their doors.
Closed in the sense of an empty building?
I mean, you're not closed in the sense that the investments are still in the regional center. The investors are still waiting for their visas.
That's not a physical concept. I bring, $100 million into the country. And I also bring in some non-citizens. And there are 500 of them. And they've all been processed through the system. And they're either citizens or they have green cards or whatever. But right now I have this empty facility. It was designated under the old laws. I'm not seeking any investments. I'm not bringing anyone into the country to be a part of this program. I'm just paying state property tax.
But I think the point, Your Honor, is that the law doesn't exempt that particular scenario. The law doesn't exempt any scenario.
The only reasonable way to read the statute is Congress could not have intended that my empty building have to pay this fee in order to avoid graft and corruption, because I'm not doing anything with it. It's just sitting there.
But I don't.
So what's the best response to that? Isn't that the argument we're being presented with? That if I were to become active, then I'd seek redesignation. And I just have a structure. There's nothing going on. No investments, no people.
I think the argument, Your Honor, is that Congress didn't parse it that finely because they required annual reports from everyone designated under subparagraph E, and they required a fee. And all of that goes to the graft and corruption that pertain to the prior regional centers, of which these are. There's
no way to get out from under this fee, even if all I have is an empty building.
Not as long as the investors are active in that regional center waiting for their visas. No.
I don't see that qualification in the law.
There's no qualification in the law, right? There's no qualification. It applies to all of the regional centers.
You just added some language that isn't in the fee provision.
Because if the regional center closed down and was gone, then they wouldn't be paying a fee anymore. And that's what would have to happen to get out of the fee provision, because the fee provision applies to everybody. There is no limitation.
Empty building.
Yes.
Where there are no investments and there are no people being brought in.
Well, there's money invested in it by the investors, but yes.
The investments have all been used up. I've made the investments. I brought in these people. The deal has been made with the United States government under this statute.
Yes, under that, yes, the fee is still owed.
So I'm inactive. I mean, the interesting thing to me, candidly, about this case is the argument is by the appellants is they shouldn't be subject to the fee. But on the other hand, they want to be able to reapply, get new investments. I'm just not clear how this works. I understand what Congress had in mind. There was a lot of graft and corruption. It wanted to tighten up the system.
I understand your question, Your Honor, and I think the government's position is that there is no limitation on the nature of when the regional center had to be designated. And if they want to maintain their designation under the law, then they have to pay the fee. Thank you. There are no further questions.
Why don't you take 1 minute?
Thank you, Your Honors. Judge Rogers, I just want to address your point. This is what Bering dealt with and begged the agency to engage in rulemaking to determine who needed to be designated, how they needed to be designated, and the injunction lasted until they granted summary judgment or the agency engaged in notice and comment rulemaking. The agency simply hasn't. The EB-5 program has been regulated by memo and policy statements essentially since 1992. That's when the last regulations came out. There was a set in 2018 that were set aside for an appointments clause issue, but this is the big question.
Wasn't there a settlement? Did the settlement require there to also be rulemaking?
The settlement did not, Your Honor, but the injunction did. And it's my understanding the agency is going to engage in rulemaking sometime in November under a different case. But right now, that's the real question, because Judge Rogers' point is the statute doesn't address any of this. And our point is under the canons of statutory interpretation that are time tested. The answer here is simple. Each regional center designated under subparagraph E does not include regional centers like my clients. Thank you, Your Honors.
All right.
Case number 24-1790. Hdeel Abdelhady versus George Washington University et al. Ms. Abdelhady for the appellant, Mr. Henry for the appellants.
Good morning, Your Honors. May it please the court, Hdeel Abdelhady on behalf of myself. We have in this case two orders that are an issue. One, denying a motion to seal on remand from this court. And the second, sua sponte, unsealing documents that were filed in support of the motion to seal and that had been sealed for nearly 2 years when the district court on its own initiative unsealed them. This court has jurisdiction under 28 U.S.C. 1291 from a final decision. The district court entered a final decision in February of 2025 after this appeal was taken. Before that, the court had jurisdiction under the collateral order doctrine. That, I believe, is no longer an issue. On the merits, the documents that are an issue are 16 non-public documents that the George Washington University filed with its Rule 12b-6 and summary judgment replies. Importantly, in this matter, those replies and the motions that it filed were companion documents, essentially one motion. The district court on remand, in the remand order, made the important finding that the documents were in fact non-public. The district court's language is they were initially non-public until, of course, GW filed them on the public docket. That is not in dispute. The university didn't contest that below, but it claims in its brief, or it refers to the documents as public documents. It didn't challenge that finding below, and it didn't cross appeal. So it can't dispute that now.
Abdelhady, how do you, we review the district court's determination on sealing for abuse of discretion, which is a fairly lenient standard. So how do you get past that standard? Where's the abuse of discretion?
Okay, well, there are.
District court.
Yes, there are multiple abuses of discretion, and I'll get to those. But let me note first that there is also a legal question here that you reviewed de novo, and that is whether the documents are judicial records, and that's CNN v. FBI and other cases. On the abuse of discretion point, there are two principal issues. One is that the district court's factual findings are erroneous. Its characterizations of the documents are not correct. For example, when it states that the documents, including GW's 12B6 reply, which is an issue, do not contain medical information, that's not factually accurate. They do contain medical information. The first exhibit to the summary judgment reply contains medical information. That's an abuse of discretion. With regard to the district court's sua sponte unsealing of the motion to seal and its exhibits, the district court's basis for that in the footnote that addresses it, not applying the Hubbard factors at all, the district court stated that the documents were public docket. They were not public docket. In fact, one of the exhibits is a sealed docket from the DC Court of Appeals. The other is a DOES docket. That is not public. That is not in dispute. And the other documents are ironically HHS determinations that the university or medical providers, in response to its subpoenas, violated HIPAA rules in disclosing medical records. Those documents also contain medical information. The district court characterized those as agency records, as if they are public. They are not public. They were never public, and they were filed to underscore the privacy interest that I asserted in the motion to seal. So those are abuses of discretion. In addition, the district court stated, again, that GW's 16 documents do not contain medical information that's not disclosed in the complaint. But this court in Abdelhady 1 already examined the record and determined that, in fact, the district court was wrong in the initial order, and it is wrong again in this remand order. So that's the abuse of discretion, or those are the abuses.
My understanding of this court's first decision was that the district court had not given sufficient explanation, which isn't to say that the decision was incorrect. And on remand, the district court did provide, much fuller explanation of its determinations.
Well, yes, it is true that the district court, or the initial ruling from this court, was that the district court did not provide explanation. However, in the decision, this court also explicitly stated that the district court incorrectly determined that the documents that GW filed did not contain medical information that was disclosed in the amended complaint that's redacted. So that was a factual error, and this court specifically stated that in the Abdelhady 1 decision. This court also stated that the medical information should be under seal, and it is not under seal. Some of it is under seal and some of it isn't. I'd like to also, Judge Rao, pick up on your point about the fuller explanation provided here. We have to maintain a dichotomy between the medical information and the non-medical information that is in the public or the non-public documents. The district court did not apply the Hubbard factors, the 5, to the public documents. It only applied it to the medical information, but we have two distinct categories of issue. So the district court did not provide a full explanation on remand. It did so with regard to the medical information, although it did make factual errors, but we don't have a full explanation, and we don't have application application of the 5 Hubbard factors. And the district court does not have discretion to not apply the 5 factors. That is not a discretionary exercise. With regard to the question of judicial records, the 16 documents that GW filed are not judicial records. They are not subject to the public access doctrine for 2 reasons. One is because they were filed in bad faith and for improper purposes. The university explicitly stated in its 12B6 reply more than once that they were public documents, that they were public records. They were not. It's never substantiated that. So that was a bad faith way to get the documents into the record on the public document for the purpose of avoiding conversion under Rule 12D, because the university asked the court to take judicial notice, and the public documents misrepresentation was essential to that. The second reason is because the district court states in the remand order that when it applied the first Hubbard factor, it stated that it considered the documents, the public had a need to access the documents because GW filed them to refute and rebut the allegations in the complaint. GW had no right to do so in a 12B6 motion, not in a reply, and not without conversion under Rule 12D. So the judicial records assumption that the district court makes throughout this remand order is not a correct assumption. That's a legal question that this court reviews de novo. League of Women Voters, In Re Sealed case, the FEC case, and MetLife underscores that documents submitted into the record on the public docket in bad faith for improper purposes are not subject to the public access doctrine. This is an atypical case, and there is no question that the university misrepresented the documents as public record. That's in its replies. We don't have a public access doctrine case. If we did have a public access doctrine case, reversal would still be warranted for the same reason that the first minute order was reversed in the first appeal. The court again stated that there was a public need, the first factor, because GW filed them to refute and rebut. That is not public need. As this court made clear in a case like EEOC v. National Children's Center, public need connotes some kind of a civic need. We don't have that here. We simply have a party filing something on the docket improperly and misrepresenting what those documents were. In terms of prior...
Let me ask you, of the 16 documents to which you refer that GW filed, how many are still in dispute in the sense that they have not been sealed and they have not been redacted?
All of the 16 documents, excuse me.
Every one of them?
No, I'm sorry, Your Honor. I don't want to misspeak. That is not correct. I was going to say all of the 16. Some of the documents have been redacted pursuant to the district court's remand order. But
how many remain unredacted?
The first exhibit to the summary judgment reply remains unredacted, and it contains medical information.
And that exhibit is a single medical record?
It's actually not a medical record. It's a DOES document that contains medical information.
A DOES, Department of Employment Services?
Yes, Your Honor. And
what kind of document is it?
It is a claim document, and
was it part of the workers' compensation claim?
That's right. It was the document that initiated that initially was the filing.
So that document has not been sealed?
That document has not been sealed.
But it was sealed by DOES by operation of law?
Correct. It was not sealed by the DOES. It was never publicly accessible. But it was.
You made these arguments to the district court?
Yes, and I submitted evidence.
What was its response as to this one document?
Well, initially, in the first minute order, the district court didn't address it. In the remand order that's on appeal now, the district court does not address any of the documents.
He does not address the claim document at all?
I believe the district court does not specifically address that document. It is not one of the documents that it ordered sealed. And I can double check that.
I'm calling you counsel, excuse me. But what I'm trying to figure out is where are you in this case? There are things that you still want sealed or redacted.
That's
There
correct.
are findings by the district court that you say are erroneous as a matter of fact. The district court has ruled, and has it not essentially issued a meet and confer order to you and GW University?
Yes, the district court did issue.
So can all of these issues be resolved? Just take a hypothetical here. You and GW, you meet, you reach agreement, and you submit a statement to the district court to that effect. Is that contemplated by the remand?
That is not
The
contemplated.
order on remand, excuse me.
I don't read the order that way. What the district court,
Could it not happen?
I don't believe it can.
In other words, you've been up here now a couple of times.
That's right.
And one of the reasons oral argument can be helpful is to anticipate in order to avoid still another appeal where you are claiming factual error by the district court as well as legal error. And I will ask counsel for GWU exactly what interests they have in fighting this. So I understand why, if there are records, when I think of medical records, I think of diagnoses, I think of tests, I think of examination records, why it has an interest in having those documents public when it has, I don't want to say settled, but the workers' compensation claim is over, although I know you don't think that was enough, but that's a different issue. So what's remaining in this case? If we just send it back to the district court and say you made a mistake here and you didn't do that there, then you'll come back and say, but he didn't do everything I want. And I thought the district court was trying to say, here on remand, here's my position, and I'm explaining it. And I'm not going to sit here, I think these are almost his words, and go through this document by document, but let the parties work this out.
Well, and thank you for that practical aspect, because that's exactly what's going to happen is we probably will come back. I will come back. I will appeal again. And I don't want to do that. And I don't think I should be here for a second time. But
No, it'd be more than a second time.
no, I mean,
What I'm
this time,
getting at
yeah.
is, why isn't the district court's meet and confer position the way this can be resolved?
Well, I don't read the ruling as a meet and confer. I read it as the district court having made a decision about specific documents.
And it said, I'm not going to go through all of this. The parties should meet and confer.
That's right. It said that the parties, that GW should confer with the plaintiff about the specific documents that are within the scope of the order. That is not all of the documents.
And what else is there?
Well,
There's 16 documents, and there's this one document that you identify as a claim.
right.
That's all that you're fighting about now.
No, that I need to correct myself. It's not the only document. That's one that contains medical information, as does GW's reply, Rule 12b-6.
So that's 17 documents?
That's 17 with that rule. That's correct with the 12b-6 reply. The issue still outstanding that the district court does not address in the remand order is that these documents were not public. They were submitted by the university.
The district court is well aware of this argument.
Yeah.
You, okay? It ruled. All right? And then it said meet and confer.
Well, I would be happy to meet and confer, But I'd also want to confer about the non-public status of these documents and the manner in which they made their way into the public docket.
Meet and confer, in my question, speculates that were the parties to meet and confer, this might all be resolved.
Well,
I don't understand why GW would want to make public information that it will be able to use in litigation that you have brought. But why would it also want to make this public in terms of any document that you and the district court agree is a medical record?
well, I believe,
Personal to you.
but the important point here, Your Honor, is that the reason why the university wanted these to be public is because it wanted the district court to take judicial notice. Without the public record claim, the district court can't take judicial notice under 12b-6
What do you mean judicial notice? Of what? Of your
of the
medical
16
records?
of the 16 documents.
But they're all personal to you.
Correct.
And you're making claims based on those records.
Well, I'm making claims. Actually, I'm not making claims based on these particular records, but that's a merits question.
No. You're not making any claims based on these 16 records?
No,
All you're trying to do is make them non-public.
correct.
You're
Yes,
not trying to prevent GW from using them
that's
and
right.
defending against whatever claims you may make.
That's right.
All right.
But I, again, and I know I'm way over time here, but again, the way that these documents got into the record in the first place
We've heard that
matters.
17 times.
Thank you, Your Honor.
All right. Mr. Ennis.
Good morning, may it please the court. My name is Jared Emig, and I represent the George Washington University. Your Honor, before I go into my outline, if I could respond to your question that you just raised, why does George Washington care? And that's a question that we've grappled with.
No. My question is, why does GW have an interest in making medical records which it can use in defending itself against the plaintiff's claims, of making the medical records publicly available to the general public? What interest does GW have when its own interests are fully protected if they're not public?
I agree, and I think the problem of the medical records has been resolved. I think this court's remand order in Abdelhady 1, the meat of it focused on medical information, the diagnoses, the doctors, the treatment. And Judge McFadden in his remand was very clear on that, he weighed the Hubbard factors and he took light of this court's ruling and held that there is no need. The public access doctrine has to take a back seat with respect to the medical records. So what Judge McFadden did was he ordered defendant GW to file redacted exhibits that make reference to treating doctors and injuries, specifically injuries that are not described in plaintiff's redacted amended complaint, because plaintiff already put those. And we did that. We complied with Judge McFadden's order. I disagree with Ms. Abdelhady on that one exhibit, the exhibit 1, which was the claim form. That contained the name of a treating physician. Judge McFadden ordered us to file the redactions. We did that. The redacted copies are now filed.
So there's nothing that's generally available to the public?
With respect to the medical treatment, no, Your Honor, unless that one carve out. And that carve out is if the cat's already out of the bag because of the redacted amended complaint.
So what's the issue here?
The issue as I understand it, are these 16 exhibits that George Washington filed in support of. George Washington filed the two dispositive motions, motion to dismiss, motion for partial summary judgment. Ms. Abdelhady opposed them, and we filed replies.
But have those 16 documents either been sealed or redacted by the district court now?
Yes, with
So
respect.
those aren't an issue
Well, no,
as far as the redaction and sealing.
just with respect to the medical information, they've been redacted and sealed. But these exhibits contain other information other than medical.
Can you give me a hypothetical?
Sure, there's a notice of controversion that GW originally filed controverting the workers' compensation case.
But that's settled, or
Yeah,
and that's resolved.
the workers' compensation case
She filed the claim and GW paid.
paid some benefits, and under the workers' compensation law, her claim remains open, at least with respect to medical treatment, for the rest of her life. So that claim isn't. But the exhibits I filed were filed to show that Ms. Abdelhady filed a workers' compensation claim, accepted some benefits, and litigated through the workers' compensation process, because that was,
All I'm getting at is you can do that with sealed documents.
we can. But
Is there any interest that you have that requires these be public?
the interest George Washington has is Ms. Abdelhady claims that these exhibits were filed in bad faith. And that's a very serious allegation. Judge McFadden found no elements of bad faith, but that remains in the public record. So to have the specter of exhibits being filed in bad faith without the public being able to see them.
But counsel, I'm just trying to understand this. All right. Of course, the claim of bad faith is very serious. And GWU wants to be able to confront that. But I don't read the district court as saying that that would justify making those records public.
No, I agree, but the district court relied heavily on the public access doctrine, which really is the basis for all of this sealing versus non-sealing. And the court recognizes, this court has recognized, that it's a fundamental principle that the public has the right.
No question about it. And this court doesn't like to seal or close arguments, much less issue opinions that aren't generally available. But there are circumstances where it's done. And I'm having trouble understanding the argument here because the district court was not suggesting, the way I'm reading his opinion, that any of the plaintiff's medical records should be in the public domain. And yet is clearly enabling GWU to defend against her claim. But that, I don't need the district court to say that because she's accused you of bad faith, you would get the right to put this, out for public consumption.
I guess I take a different view.
Okay.
We have the public access doctrine, and this court has held the public should be able to see the information that the court had available to it in reaching its decisions.
It should be. And, you know, even better than I, there are multiple occasions when that doesn't happen because of the interests that people have in their personal medical records.
And I think Your Honor's concern about medical records has been alleviated because all that's been redacted. We're just arguing over other documents, these 16 exhibits that no longer have medical information. We're just talking about, does the body of these exhibits, which include a transcript from the workers' compensation proceeding that didn't deal anything with medical records, It has correspondence between Ms. Abdelhady and GW's counsel. It doesn't contain any medical information. So that went to the heart, or that supported GW's reply on its dispositive motions. The public should have the ability to see that. Now, the fact that Ms. Abdelhady doesn't want the public to see it, that's really not a fact. That's a factor, but it's not really strong enough to overcome the public access doctrine. And it goes back to the heart of the question, why do we care? Why does George Washington care? Your Honor, when Ms. Abdelhady filed a 67-page complaint with 10 counts, including RICO, violation of her civil rights, fraud, abuse of process, those are not the types of claims that GW typically sees. That shows up in the internet. It shows up on different listservs filed by plaintiffs. And the headlines are GW sued for racketeering. And that's out in the public space. Then we have the plaintiff filing within her amended complaint. She goes into great detail about her workers' compensation case. She states that she filed it. She states that George Washington filed a notice of controversion. She said GW scheduled independent medical evaluations. GW had a nurse practitioner or a nurse manager assigned to it. GW wrongfully paid or didn't pay benefits. They didn't pay her wage stacking benefits. Explicit detail about her workers' compensation case. The exhibits that we filed simply correlate to those events.
So what do you understand the judge's current order to mean when he says, I'm not going to go through all these documents, the parties should meet and confer?
Yeah, I think what the judge says, where there's medical information, the parties should meet and confer. And I again disagree with Ms. Abdelhady. He explicitly stated meet and confer. When this order came in, I took first stab at preparing redactions, forwarded them to Ms. Abdelhady. She returned comments, and ultimately we filed the redacted comments. Medical stuff is taken care of. Then I read his order saying that the other exhibits, these 16 exhibits, since they no longer contain medical information, they fall within the public access doctrine because they were submitted to persuade the court. And the court issued its decision, although it may not have explicitly relied on it. It's public access. The public should have access to these documents. I think my time is up unless there's other questions.
All right, thank you.
Thank you.
All right, why don't you take a minute?
Thank you, Your Honors. First, the university has not articulated a reason why these need to be public. In terms of the bad faith issue that came up after it filed these documents, it was not motivation for it to file in terms of refuting any bad faith issue that was in the record. So there's no reason that GW has articulated still. I have an interest in the non-public status of these documents. It's provided under the district law, the WC Act. These are sealed documents, and it matters how these documents made their way into this record on the public docket. And that's what this court has said in the In Re Sealed case, FEC, in the League of Women Voters cases, et cetera. The district court was not authorized to consider these documents under Rule 12b-6, and it did so, and it was not performing a judicial function. They are not judicial records. GW says the bad faith claim is serious. Indeed, it is. What's also serious is GW's claim in its brief in this case in the district court that I, an attorney, filed a sham affidavit in opposition to summary judgment, and that I denied filing the WC claim. None of those things are true, and I would urge the court to carefully review the record. So we have the bad faith and improper purpose of avoiding Rule 12D, plus the additional bad faith and improper purpose of the sham affidavit fiction that GW still cannot cite. This is now the third proceeding it's an issue. That's also serious. So, seriousness goes both ways here. The medical information, you were just told there is no medical information. That's factually incorrect. At the Joint Appendix Sealed 20 is the claim form that references diagnosis, and it also references provider names. That remains unredacted on the public docket. And 71 of the sealed supplement, that's the 12B6 reply, screenshots of DOES documents that are an issue also containing diagnosis. That is not public. It is not in the redacted amended complaint. This court should reverse. And again, I urge the court to think about how these documents made their way into the public document docket. That matters. Thank you very much.
Case number 24-5207. Patrick J. Mahoney, Reverend versus United States Capitol Police Board in its official capacity at all events. Mr. Stringer for the events, Mr. Dixon for the.
Mr. Springer, good morning.
Good morning, Your Honors, and may it please the court. Brian Springer on behalf of the federal government. Plaintiff is permitted to engage in his desired demonstration activities on the sidewalks immediately in front of the House and Senate stairways and on the various other open spaces throughout Capitol grounds. At the same time, the regulation at issue directs that conduct off of the stairways themselves to protect the safety and security of the Capitol and the people who work there. The regulation is constitutional on two independent bases. First, it is a reasonable regulation that applies outside any traditional public forum and preserves the stairways for their intended purpose. Second, even assuming that the stairways are a public forum, the regulation is a valid time, place, manner restriction that relates to the location of speech. I'd like to address those 2 points in turn, and I think that this court's decision in Hodge is a helpful starting point for the public forum analysis. That case held that the Supreme Court Plaza and the staircase leading up to the plaza are a non-public forum.
So, well, Mr. Springer, first, do you think it's fair to say that historically the Capitol steps have sometimes been a designated public forum open to all manner of speech?
Your Honor, I'm not sure that I would say that they've ever been a designated public forum. Designated public forum usually means that it's fully open to the public. And here the evidence in the record shows that sort of over time, the conditions on which the public has been allowed to demonstrate have changed to some degree. We don't have kind of the exact situations, but I think it's changed over time. But even if it were a designated.
Was it a designated public forum?
Your Honor, even if there were times it was a designated public forum starting, right after the September 11th attacks in 2001, the board has closed these off and it's allowed to do so, even if this were a designated public forum before that.
So let me ask you a more basic question. In Dellums, the opinion of this court incorporated the decision of Chief Judge Harold Green in Nicholson, saying that the principles identified by Judge Green applied and were binding. That is a case involving the Eastern Capitol steps, the very steps we're talking about here. And Judge Green's opinion, which all three judges on this court viewed as setting forth the principle, involving demonstrations on the Eastern Capitol steps applied. Is not this panel bound by Dellums?
Your Honor, I don't think that Dellum specifically addressed the question of whether or not this, this set of stairways is a public forum. It is
With due
true.
respect, I'm literally quoting from Dellums, where twice the court said the principles identified in Nicholson control here. And while in the Dellums case, people had actually been arrested for not leaving the steps. Why isn't that case directly on point here?
Your Honor,
When this case first came to my attention, I thought, why hasn't Dellum settled this for years?
And again, I don't think that it is true that Dellum's points to Nicholson, which I don't think was particularly disputed in that case, and it does talk about the principles there. It doesn't
Disputed, the principles were adopted by this court. That's in the opinion in two places.
Your Honor, even the district court in this case said that no prior case had ever analyzed the question of whether the stairways are a public forum. And Dellum's was specifically a question about a Bivens cause of action and whether to imply a Bivens cause of action. I also...
Much more than Bivens, as you well know, counsel.
Your Honor, I think that case is largely about the principles of Bivens, and it also is factually...
Talking about what is the Capitol building, what are the Capitol steps? And we're talking about the very same steps that are involved in this case. And this court agreed with the principles that Judge Green had identified about the steps. That's what I'm trying to get at. I don't know why you're fighting me on this.
Your Honor, I mean, a couple things that I will say about Dellum's. I mean, I think, first of all, it is true that it talks about some of the principles in Nicholson, but it doesn't actually do a full analysis of the public forum, which has developed in the interim, in the years since then. I will also say that in Dellum's, the particular protest at issue was being led by someone who was in Congress, by members of Congress,
Actually,
and that...
there were 2,000 people who marched up, and at least 2 members of Congress were mentioned. All right? But lots of people were arrested. This is a protest against the war. All right? I don't know how we ignore that. This is a peaceful protest. And the problem was when the Capitol Police told the demonstrators to leave, they wouldn't leave. And so they were arrested.
Sure. I mean, I think a couple of things that are important here. I mean, one is that we're talking about the public forum analysis, which again, I don't think that Dellum's actually does a full public forum analysis. Neither really did the Nicholson decision. It just said, we think that this is a public forum without much analysis.
It said more than that. It talked to the history and the purpose, the architecture, etc. I don't know why the government is fighting this case. Because Judge Green interpreted the statute in a manner that allowed regulation, all right? That it wasn't a public forum like the streets and passageways, that there are government interests that have to be taken into account and can be taken into account consistent with the Constitution.
I think that's right. Even if this court were to accept that the stairways are a public forum, this is a valid time, place, manner restriction because it's just about the location of speech. And all that the restriction at issue does is it directs this conduct off of the stairways onto the sidewalks below. And the reasons for that are spelled out by the Capitol Police Board, which is that they need a sufficient buffer zone around the Capitol building in order to protect both the building itself and the people who work there.
But they allow congressmen and senators to bring anybody they want, and they allow people who are there to join these demonstrations that are sponsored by congresspersons and senators. So that defeats your security concern if members of the public can just join, they haven't been through any security.
Your Honor, I don't think that's right. The board treats that situation as qualitatively different than one where it's just the public demonstrating, because these are events that are hosted by Congress members in their official capacity.
Say, sure, join me on the steps.
Your Honor, it's true.
And the police, Capitol Police don't know who those people are. They haven't been through any security.
Your Honor,
They have bombs or whatever.
Your Honor, I mean, a few points on that. I think, first of all, usually when these events happen, the Capitol Police are alerted ahead of time so they can post additional security and have extra people there. They also trust that members of Congress, because again, they are hosting these events in their individual capacity and required to be personally present the whole time.
No question about it.
They're treating those as different.
Faith of the members of Congress, all right? But the members of Congress don't have control over people who join them there.
But Your Honor, again, the board is allowed, and again, we're sort of at the point where I think we're talking about this in terms of intermediate scrutiny. We're assuming that this is a public forum.
Yes, because of the history of it. And if it's not historical back to ancient times, by designation.
You know, I mean, again, I think historically that's not the way these stairways have been treated, and that's not the way, they're integrated into the actual building itself.
I thought that was not an accurate statement. It endorsed the principles found by Judge Green. And I don't know how we can ignore that. And I don't know how the government can ignore it.
Your Honor,
And yet, Judge Green clearly acknowledged that there were important governmental interests. And the question is, does the rule that's challenged here do that? This member exception.
Again, Your Honor, I mean, I think the way that the board has understood this exception is that it treats it as something that's qualitatively different. And I would point this court, if it's applying
Different than what?
qualitatively different than just members of the public hosting their own demonstrations on the steps, sort of on a whim, as they want, those can be inherently unpredictable.
If I can ask you, maybe following up on Judge Rogers' question, I mean, even if we were to assume with the government that this is a non-public forum because it's, part of the building or, for some reason, it's a reasonable place that, it's not a traditional public forum. Even if we assume it's a non-public forum, I'm interested in understanding how we decide that this regulation is reasonable. So perhaps it would be reasonable if only members could speak or demonstrate on the steps because it's their workplace, but including anybody that a member chooses to sponsor to allow to be part of a demonstration. How is that reasonable?
Sure, I mean,
even if we're just in the land of reasonableness, how is that exception reasonable?
Sure, I think it's still reasonable. And again, I would point the court to what the regulations specifically say. So I think that this is 12.2.20. What it says is that when Congress members are having these sorts of events or, doing their own demonstration activities, it has to be in their official capacity as a member. These aren't just them expressing personal views. This is them expressing a view as a member of Congress. And as part of that, they're allowed to bring members of the public sort of under that umbrella, again, based on this idea that there's going to be trust and that Congress members aren't going to do something that's likely to risk some kind of threat to the Capitol, but they have to be doing this in their official capacity as a member. They have to be present. And it's, an event that they've organized themselves or sponsored.
So, but what about the unbridled discretion, right? So are there any particular criteria that are applied to who can demonstrate with a member in their official capacity? It's just up to the member, presumably, to determine who they want to support or sponsor for demonstrations and protests, even in their official capacity.
So
there's a lot of discretion there. And if you don't have connection to a particular congressman or senator, then you're out of luck.
Sure. Again, I don't think that this implicates the unbridled discretion doctrine. You know, Judge Millett had raised some of these concerns with a prior version of the regulation. And as part of this litigation, the board amended the regulation in particular to add that in the official capacity as a member, again, this is members of Congress who work at the Capitol holding events.
Explain to me why the in their official capacity eliminates the discretion problem. Because sure, in their official capacity, you know, members could presumably speak on the steps, but when they're bringing members of the public in or as part of their official capacity, you know, participating in a demonstration or First Amendment activity, but that's still discretionary.
Your Honor, it may be discretionary in the sense that the members get to choose what events they want to hold themselves, but they're holding the event themselves. And if they want to invite others in, that's okay. They're not sort of going out. What the problem or potential problem that was identified with the previous version of the regulation was that members of Congress could advocate for certain things and say, I'm going to let you speak and I'm going to let you speak. This is them out there speaking themselves. And if they want to invite people to join them, they're able to do that.
So it is the member speaking themselves.
Your Honor,
Not necessarily a member standing by while other people are speaking.
Your Honor, I don't know that there's a
Does that
specific, I don't really think that it entirely, I mean, I think that this event itself is one that the member is endorsing. You know, the member is saying, I am holding this event. This is an event I'm holding in my official capacity. And therefore, because of that and because of the underlying trust of members of Congress and them sort of taking responsibility for the fact that this is the event that they're holding, that's the reason that this is treated differently and doesn't implicate some of the problems that plaintiff is raising.
And the discretion is okay because it's in their official capacity. And of course, in their official capacity, members can speak about or support whatever speech activity they want to.
I think that's right, Your Honor. And again, I mean, you know, I will say as well that if you look at the record here, you know, the types of topics that are covered, you know, there's no content discrimination here because the topics that are covered range the full gamut of political and social, you know, issues of the day. That's what Congress members are going out there, you know, on the occasions that they do this to speak about. It's about different, you know, things that implicate their constituents, and they're out there speaking as a member. Again, by regulation, it has to be in their official capacity.
I guess my concern, again, is that following up on Judge Rao's questions, attributing, you know, good faith and intention to the members of Congress does not resolve the problem of safety if you allow members of the public to join in the demonstrations. And we know that for all kinds of different reasons, which you cite about how many threats are made, how many times members of Congress are injured, even at their own events. So that this notion, I'm trying to divide in my own mind the principles that Judge Green laid down, that this court accepted, that there can be peaceful demonstrations on the Capitol's steps, the eastern steps, and that the types of events that happen on 9/11 and on January 6th, no regulation is going to provide protection because those events involve persons who are not going to follow any rules or regulations, who are not going to abide by physical barriers that had been placed, who damaged the Capitol building. Capitol Police died and were injured. So that type of lawlessness does not mean, or the government seems to be telling us it does mean, except for members of Congress, you close the steps.
So, Your Honor, I think a few points to that. Specifically with respect to the members of Congress, as I mentioned before, usually when these events are happening, members of Congress are telling the Capitol Police ahead of time so there can be added security there in case some kind of issue arises.
You know, counsel, and you tell us all these threats against elected officials. All right? The Capitol Police are not in a position to protect against all of them, but they can do what they can. But once you let members of the public in, or people who haven't been screened in any way, you undercut the whole rationale. And it doesn't mean you can't have time, place, limitations.
Your Honor,
To close the Capitol steps unless a member invites members of the public?
Your Honor, I think that this is a reasonable trade-off that the board has made where it's saying members of the public by themselves cannot demonstrate on the steps. They're of course welcome to engage, as plaintiff can here, in their demonstration activity right on the sidewalks immediately in front of the steps, as well as the various other places throughout Capitol grounds.
So we distinguish between the exterior and the interior of these historic buildings. But for some reason, we are now parsing off the steps which are part of these buildings. This is classical architecture at its zenith. Steps were a big part of these buildings. They're not just rectangles.
Your Honor, I think that actually helps our point. These are parts of the building.
Demonstrating there peacefully for years. And you won't just close it. Except when a member says, it's okay with me if members of the public come.
Your Honor, again, I think there are a number of limitations on what's going on when Congress members are doing it that allows the board to treat that as a qualitatively different situation than when members of the public just sort of on a whim are out there doing it. And
no whim. I'm just trying to deal with the realities of life. Everybody's got a gun. Members who run for office, who take positions, individuals who take positions run the risk of injury. And people are willing to take those risks. But does that mean we transform the Capitol building, which means so much as an emblem of democracy? Our legislative building is now closed off beyond reasonable time, place, and circumstance. That's all I'm getting at. I don't understand how you can cite all these statistics about all these additional threats to members of Congress and think that we're going to be fine if the member of Congress sponsors an event and invites members of the public.
Senator, again, I think the board thinks that that's a qualitatively different situation. Just to address, I think, the other question here, I don't think that this in any way, disrespects the principle that there are numerous places on Capitol grounds where people can protest and can speak to their legislators and the public. That's exactly the trade-off that the board has made here, is it's directed the conduct off of the stairways themselves. Again, the stairways lead up to non-public entrances for the House and the Senate buildings. If you go through the doors at the top, you're right at the House and the Senate chambers. This is where the board has determined it needs a buffer zone so that if things turn violent, it's not saying all protests are violent, but if they turn violent, it needs to have sufficient time and space to respond to that situation. And this is the buffer zone that it thinks has explained is necessary in order to provide at that time and space.
Can I just ask you a factual question? Is there any dispute about the elevated area right immediately beneath the steps? Is that considered part of the sidewalk? Or is that area also in dispute?
So, Your Honor.
The record is a little bit unclear.
So, Your Honor, yeah, there's the set of steps that comes down, and then there's sort of an elevated area. That is the sidewalk itself, and it's elevated because it's a curb where after the curb, there's an area where cars are able to drive.
So
And that sort of
elevated
runs.
area, you don't dispute that's a traditional public forum. It's a sidewalk where people can protest. So right at the bottom of the steps.
The one clarification I should just say is that that's true in front of the House and Senate stairways, in front of the Capitol steps, in the steps that lead to the Capitol Rotunda in the middle. Right in front of it is the roadway, so that's an area where you're not allowed to protest as well.
Because it's a roadway.
But there is a sidewalk that runs all the way along the front. It's, both in front of the House and Senate stairways, and then there's a couple other pieces of it that sort of run all the way along the eastern side. And all of those are areas where plaintiff and others are allowed to engage in their desired, protest activities.
Thank you.
All right, well, I'm confused about that then, because looking at these photographs,
Right.
I thought, and the sidewalk is not before us because the district judge just talked about the steps. I know the plaintiff disagrees with that, but looking just at JA 115, I thought the northern and southern sides of the building, that those parts of the sidewalk could not be allowed for demonstration activities.
So, Your Honor,
Wrong about that?
so yeah, I mean, maybe the helpful, let me just pull up the.
Look at JA 117, for instance. This is the house steps. And I thought the front sidewalk was okay, but the north and south sections weren't.
So, Your Honor, in front of it is okay. On the sides, I think there's some, in the map that's in the record, it's red there, but the Capitol Police doesn't enforce it as to that piece because that's also a sidewalk. And so the places that count as sidewalks that look like traditional ordinary sidewalks, which again is what this court addressed in its Letterman decision, those are places where, there isn't a restriction or where the Capitol Police does not enforce the restriction.
We're just talking about the steps.
Yeah, my understanding of what the district court addressed was just the stairways themselves.
Okay. Thank you.
Right, unless there are any other questions.
I have a question that I would agree with you, but for this exemption. And I think it puts, it delegates too much authority to the members of Congress. And some more of these photographs indicate that some of these demonstrations sponsored and led by members of Congress are anything but peaceful. And I don't know, it's not something we can take judicial notice of, I guess, but there are members of Congress who do not always remain peaceful. And that's what worries me is you prevented one person from a vigil, which according to the dictionary is a watch. It says nothing about doing anything vocal, doing anything expressive or communicating in any way. And yet you've left this huge gap for members of Congress. And just looking at a photograph, page 156, there must be 150 people all over the steps. There's another photograph. Well, I don't have to go on with this, but that's what concerns me is the exemption just seems to wipe out the intent of keeping these steps not keeping them safe for the members of Congress, keeping them away from demonstrations as they're defined in this definition.
Shannon, I want to make one clarification before I get to the heart of your question, just about plaintiffs' demonstration activity specifically. If you look at JA 16, JA 24, JA 403, and particularly JA 403, which is paragraphs 35 to 36, the events that he has proposed holding are ones where they would be praying out loud, they would attract large groups, he would be holding signs that express particular views. I just want to make clear that this isn't, part of what the board is worried about is the sort of activity that is organized and conspicuous, expressive acts that are likely to draw a crowd, that those are likely to create security and access concerns, especially because things are inherently unpredictable and can change on the turn of a time.
Demonstration activity and all the ones you've listed can be done by just one person.
It can be done by one person, but I think there's two important, respects to that. One is the Supreme Court's Heffron case makes very clear that the board is allowed to consider things, sort of in the aggregate. And so it's not just a question about one person. It could be a bunch of single people. And the real problem is that it is both the case that one person can pose a threat, but also that something that starts as one person or starts as something that's peaceful can quickly turn into something that's violent. And all that the board is trying to do here is preserve enough space and time so that they can do something. Just to return, I think, to the heart of your question about the member exemption. Again, I think the way that the analysis runs, and we have sort of two separate questions here, one about whether or not this is a public forum, and then a separate about whether or not, this passes intermediate scrutiny because it's a time, place, manner restriction. And I think your question really goes to the second bucket. And here—
It's a non-public forum myself. So it has to be reasonable, and that's why I don't think this exception that swallows the rule that prevents demonstrations, I have a problem with whether that's reasonable.
Sure. I think it's reasonable. So first of all, these demonstration activities by members of Congress are as far as I understand, are relatively few and far between, just to give you a sense of how often they're happening. But again, the reason that the board thinks that they're different and treats them as qualitatively different is that this is, and all of the things that are in the record happen before they change the regulation. But what the regulation makes very clear is that these are events that are happening in the Congress members' official capacity. This is them throwing something, hosting an event. And so the likelihood that they're going to continue to stay there if things turn violent or host an event that they know is likely to cause some kind of threat to the Capitol is the reason that the board, it doesn't think that those situations are very likely. And it also is able to coordinate with them ahead of time and post additional security in those particular circumstances that it can't have around the clock.
Okay.
So it's going to be by invitation only.
Your Honor, I don't think it is by invitation only. This is the Congress members.
That's the problem, isn't it? One person is out there and passersby want to join that person in a vigil or in prayers.
Your Honor, I think that's the reason that it's been.
It may be that the leader has announced that this vigil will be occurring. And the speaker will be there. And hundreds of people want to come.
Yeah, I think that's the reason that the board is worried about it being an individual member of the public. When it's someone from Congress, there's, advanced planning and there's things that are able to go on and additional protection.
House. He is a member of Congress.
That's correct, Your Honor.
He wants to join the vigil. And the leader of the vigil has announced he will be conducting this vigil, and a lot of other people want to come. So you end up with a crowd of hundreds of people.
Your Honor, again, the way that the regulation reads, it has to be in the member's official capacity. I don't know if they're just informally joining that would count. It's usually them hosting an actual event or going out to speak themselves.
Formal invitations, because a member can host something by saying, I'm happy to sponsor that vigil. All right. But, the members, you can't control everything that goes on, even for events they sponsor.
Your Honor, I mean, that's true, but this reflects that reality because again, these are happening, not with a huge amount of frequency, and the Capitol Police can have additional security in those situations because these are people who work at the Capitol and are working with the Capitol Police when they're hosting these events to make sure that they stay safe.
You're saying these events happen infrequently. I don't know where the statistics are on that. And of course, around election time, there are lots of events. Secondly, I'm concerned that you acknowledge that the Capitol Police, even though these areas are designated in red, they are in their discretion just deciding where to enforce these things or not. So even though somebody's in the red area, maybe if the Capitol Police like them, there will not be an arrest.
I don't think that's right. I think this is the way, again, I think what the Capitol Police has done is it has distinguished between the places that look just like traditional public fora, that look like the ordinary public sidewalk, the ordinary public park. The stairways do not look like a traditional, this is not a traditional place where people would go to express ideas and communicate ideas. And that's the reason for the distinction.
History is wrong. All right, you can go back to ancient Greece. All right, and look at the steps where people spoke. So, even under Judge Henderson's question about a non-public forum, aren't there problems with the exception?
Your Honor, again, I don't think that there are problems because when you're asking the question in the non-public forum, you're asking the question of reasonableness, and particularly, are you preserving this property for its intended use? And here, I think that's exactly what the board is doing. The board is saying these are steps that lead to non-public entrances for the Capitol. So people who work there are allowed to, be there and protest because that is the place they work. Otherwise, you keep them, you make sure there aren't demonstration activities happening there that can threaten either the safe passage or, access to actually getting into or out of the Capitol building. And so it's preserving them, the stairways, for what they're intended to do. And that's the question that gets asked when you're asking the reasonableness question.
So what happens to all the camera people who show up and block the passageways? I don't understand this notion about, we can have all these demonstrations in the streets and the passageways. That blocks the Capitol Police ability as well.
So, Your Honor, to the extent that there are protests that are happening on the sidewalks, the regulation specifically says that the protest can't block, can't impede the flow of traffic. That's part of what's built into them doing a demonstration in that area. To the extent that a member of Congress is hosting one of these events, again, usually the Capitol Police know ahead of time so they can alert members of Congress, this is going to be happening, use a different exit. And while the event is happening, there are people on the steps, but then they are cleared out as soon as the event is over.
Right now. But 12.2.20, which sets out demonstration activity by members of Congress, as I am looking at it, doesn't say anything about giving notice to the Capitol Police ahead of time.
Sure, it isn't explicitly required, but again, these are people who work at the Capitol and the Capitol Police are there to protect them. And my understanding is that the way, the normal practice is for them to give advance notice that this is going to happen. They don't have to, but they often do. And so then the Capitol Police are able to post additional security.
If they decide not to, there's no way the Capitol Police would be prepared for, say, a demonstration of 200 or 300 people.
Your Honor, yeah, my understanding is that, usually, especially when it's a big event, it's something that is communicated to the Capitol Police Board ahead of time. Because again, the Capitol Police Board is working closely with the members of Congress. I mean, they're there to protect the members of Congress. And so usually the way that this runs in practice is that there's advance notice, there's planning about what kinds of things are you going to have, and then they can also post additional security as needed.
Well, actually, the District of Columbia has some permit requirements. The Park Service has some permit requirements. All these groups get together and talk to one another. They probably do it electronically now. So when an application comes in, they all know. So, yeah. So you would want the court to affirm in full?
Your Honor, we're asking.
Talked about the remedy at all, but.
Your Honor, we're asking the court to reverse. Obviously, if the court disagreed with, the government's arguments on the merits analysis, we think that the proper scope of the remedy, it's very clear under the Supreme Court's recent decision in CASA, which was decided after the district court's decision.
District court, but.
Your Honor,
you would affirm in full the regulation as consistent with the First Amendment.
Your Honor, we'd ask this court to uphold the regulation as consistent with the First Amendment.
All right. I'll give you some time in reply. Mr. Dixon.
As it goes. May it please the court, Josh Dixon on behalf of appellee Reverend Patrick Mahoney. The district court got this case exactly right. The Capitol grounds is a traditional public forum. The regulation is not narrowly tailored, and the district court did not abuse its discretion in entering a universal injunction against the regulation.
Mr. Dixon, before it leaves my mind, what if we lopped off the member exemption?
The regulation would still be unconstitutional under the district court's own reasoning. The Capitol grounds are a traditional public forum. Even if the members are not allowed on the Capitol steps, individuals are allowed to have lunch, walk their dogs, sit and talk the issues of the day, just like they would be in any other sidewalk, street, park, whatever the case may be. And the regulation is still not narrowly tailored under the precise logic of Lederman.
Mr. Dixon, it seems to me the district court's opinion does create some line drawing problems. So district court says we're only addressing the steps below the barricade that was put up by the Capitol Police, but that's a temporary barricade. So below the barricade is now, under the district court's reasoning, a traditional public forum. What if the Capitol Police move the barricade either down the steps or higher on the steps? To affirm the district court's ruling, we'd have to conclude that some part of the steps is a traditional public forum, and I'm not sure how we would draw that line.
I don't think that's right, Your Honor. The reason that Reverend Mahoney wanted to go out there on the Capitol steps, and I'm not sure that this timing is crystal clear from the briefing, but Representative Bush was out there July 31st, give or take, until August 3rd, 2021. Reverend Mahoney decided to go out to literally the exact same place where Representative Bush held her 4 or 5 day demonstration. A few days later, I believe was August 12th of 2021. He's not seeking to go above the barricades. Representative Bush didn't go above the barricades. This court doesn't have to rule above the barricades in order to decide this case.
I know, but the determination that below the barricades is a traditional public forum means that the Capitol Police can't just close it off for security interests, for instance.
It may very well be that the Capitol Police have a different interest above the barricades. Presumably, they put the barricades there for a reason. We didn't explore that because Reverend Mahoney, again, didn't want to demonstrate above the barricades, but it may very well be that the considerations that caused the Capitol Police to close the steps above the barricades to even individuals sitting, talking, having lunch would also justify prohibition
I
on
guess
speech.
at most, though, the fact that people are engaging in activities below the barricade perhaps suggests that below the barricade is a designated public forum, or sometimes the Capitol Police allow that area to be, a designated public forum where people can engage in First Amendment activities.
I respectfully disagree with that framing. The Jeanette Rankin Brigade case in 1972 said the Capitol grounds are a public forum. The
Well, but of
Liederman
course, in
case.
this question, are the steps a part of the building or are they part of the grounds? I mean, that's the whole crux of this case.
Understood, Your Honor, but Liederman follows up with that and says the working presumption is that the Capitol grounds are a public forum. In order to demonstrate that it's not, the government has to show that the property in question is inconsistent with public assembly and debate. On this record, the government cannot make that showing given what it allows on the steps.
Let me ask you another question. So if the Capitol Police had information that there was some threat to the Capitol, that people were planning some kind of violent demonstration or, violent activity on the Capitol grounds, could they then close the steps to that activity?
I believe so. And the traffic regulations give the board that authority. I don't remember what year it was. I believe it was January 6, 2023.
So
They did for that day.
If they can close the steps, then doesn't that take it out of the realm of being a traditional public forum? If even on your account, they can close the steps in order to preserve the security of the Capitol, then at most, it's at times a designated public forum, but not a traditional public.
To be clear, I'm not suggesting that the Capitol Police could close the steps permanently. What they have done in the past is close it on January 6th, for example, 2023. That's a permissible restriction, even in a traditional public forum. But closing it fully creates a non-public forum by the government's own ipse dixit, which we know the government can't do under the Grace opinion, under the Liederman opinion.
So what if the Capitol Police were to say, we believe the Capitol is, credibly under threats of violence most of the time, and so we close the steps to First Amendment activity? Your reasoning that would be okay, but that also is incompatible with the idea that it's a traditional public forum.
Obviously this is a hypothetical. I don't know the evidence that we would be talking about. There could be a set of circumstances in which a closure more than a day would be permissible. In the wake of January 6th, the Capitol Police closed entire Capitol Square, which is a city block, until we filed our lawsuit in August of 2021. So it was closed for 9 months. Part of the reason we filed our lawsuit was because we believed that was too strict of a regulation. And in fact, after we filed the lawsuit, the government did reopen Capitol Square for demonstrations. So, it may be that more than a day is permissible given the nature of the threat, but we would have to evaluate that on a case-by-case basis. What we do know is that today, the steps below the barricades are open to members of Congress at their whim, individuals to sit, stand, eat, walk, pray, whatever they want to do on them. I want to address, if I may, the member exemption, because I don't think that was clear. The way that the member exemption used to work, it had 3 parts. Members can be exempt from demonstrations they organize, demonstrations they sponsor, and demonstrations they advocate for. When we originally sued, advocate for was part of the exemption. As part of the settlement in this case, that was taken out of the traffic regulations. So the 2 parts of the member exemption now are the member organizes or sponsors the demonstration. The member organizes it, that means that's the member's speech. If the member sponsors it, that means that the member is going to bat for someone else. Moms for gun control, whatever the case may be. The speaker has the authority to give that organization or individual the right to speak on the steps unencumbered by the traffic regulations.
Well, it seems, you're talking about 12.2.20 now, right?
I believe that's correct.
Regulation. So that is connected by an and. So now there's an exemption if it's being done in the member's official capacity, it's being organized or sponsored, and the member is personally in attendance.
Correct. I'm sorry. All those three things are required in part
You
B.
can't just sponsor or do something in your official capacity. It has to be all three, A, B, and C.
Right, but in B, it says organized or sponsored. And so the member to sponsor, it's being done in the member's official capacity, whatever that means, sponsored, and then the member is personally present. So the member can, in his or her official capacity, sponsor the demonstration activity of someone else, and it can continue so long as the member is personally in attendance.
So let's assume for a moment, I know you disagree with this, that it's a non-public forum, that the steps are a non-public forum. Why is the member exemption unreasonable?
Well, the regulation is, put aside the member exemption for just a
The member
second.
exemption is the most, if it is a non-public forum, then they can be closed to most demonstration activity. And I think Judge Henderson and I have focused on this exemption as being of concern in terms of the reasonableness of the regulation. So can you speak to that?
I can. Let me just say this real quickly. The Jews for Jesus case was closed to all First Amendment activities. That regulation was so broad. Of course, it doesn't matter what type of forum it is. This regulation is similarly so broad. There's no restriction on the demonstration activity. It has to be the type that draws attention. It could cover two people talking on the Capitol steps.
So overbreadth makes it unreasonable in part, in your view?
In part, yes, Your Honor. This member restriction also is unreasonable as we briefed it under the unbridled discretion doctrine. As Judge Millett concluded, there is no limitation on the type of speech that a member can choose to sponsor. So if a group comes in and says, hey, we want to speak, the member in his or her absolute discretion can allow that individual or that group to speak on the steps. That's an unbridled discretion problem, even if it's a non-public forum under Mansky.
What do you make of the government's argument that because it has to be in the member's official capacity, then we're not as concerned about unbridled discretion because members obviously have discretion about what type of speech they want to engage in or sponsor?
This is the government authorizing the speech of a third party. Whether we're talking about that in the member's personal capacity or individual capacity, it doesn't matter. If someone is hired to be a censor, they are acting in their governmental capacity, but they are still censoring. Here, the members are, whatever capacity they're acting in, acting as a gatekeeper in their absolute discretion as to who gets to speak on the Capitol steps.
Do you think the same problem would exist if the only exemption was for actual member speech, members themselves speaking, without being able to, without having any discretion to include or sponsor other people's speech?
Can individuals come and participate with the member in the member's speech in this hypothetical?
No, the regulations otherwise, no demonstrations, but members can speak on the steps in their official capacity.
There may be, in that situation, like the presidential inauguration can occur. It may be that if there is a law that is passed that allows a certain type of demonstration, say a 9/11 remembrance or something along those lines, then that the speech would, just like in the Answer Coalition case, that might be governmental speech. But when an individual congressperson goes out and expresses his or her view on the Capitol steps, that's not governmental speech. That's the congressperson's view. Even if it's official, the congressperson doesn't have the authority to announce the views of the United States government. For example, Representative Bush's demonstration activity protesting.
I'm not suggesting necessarily it would fall under governmental speech, but that it would be reasonable to say we have security interests in demonstrations on the steps, and the only type of speech we're going to allow is that of members, going in and out who may want to speak to the public or to the press or whoever. Would that be reasonable? If it's a non-public forum, would that be a reasonable thing connected to the purposes of the regulation?
My one hesitation is there's no members that are going up and down the steps and entering the building that way, typically. I mean, the government entered into a binding stipulation in this case saying that members typically enter the building through means other than the steps. And so to conceptualize that the steps as their quote unquote workplace, they're just in passing, walking by, It's just not accurate.
Well,
It's
they're
not-
staffs.
I'm sorry, Your Honor.
They're staffs, STAFF.
The record, I believe, establishes the exact same thing. And that's another point about this member exemption. Are we granting it because they work in the Capitol or because they're Congress people and their speech is special somehow? If it's because they work in the Capitol, then why aren't their Capitol receptionists given the same authority? Why aren't the groundskeepers given the same authority? This is not just about working in the Capitol. It's because we, the Capitol Police, is valuing their speech different from the speech of the rest of us, which is a significant problem. We're talking about discrimination on the basis of speaker identity.
It's true, for instance, on the White House grounds, the president or vice president or other, senior officials can speak on the White House lawn, but members of the public cannot.
I don't believe this court has ever held that the White House lawn is a traditional public forum. We're talking about speaker-based identity in a traditional public forum, which is impermissible. I want to make one more clarification. The way that this case was litigated, we challenged the steps themselves, the sidewalks at the base, and then for the center steps, the rotunda steps, there's not a raised sidewalk right there. There's just the plaza. And so we allege that all three of those areas, the sidewalks, the steps, and the plaza at the base were part of the area where Reverend Mahoney wants to demonstrate. And the district judge on page JA 446 noted that those were the areas in question. I would also like to point out that under the demonstration areas map on page 396,
Let me get back to what you just said. I don't see the significance of that since he explicitly, at least in 2 or 3 places, said, I'm ruling only about the steps. And I think he may have even said how many steps there were. I can't remember now.
There was a place where he did that, but as I understand the opinion, he was defining the steps, using the term steps, quote, to mean these areas that he's described on JA 446. You can see in the map that Judge Boasberg has circled the areas in question on that page. The government today and in their reply brief says, we're not talking about the sidewalks to the north and south of the Capitol steps at the base. We agree that those are a public forum. If you look at the demonstration map on page 394, those sidewalks are in the no demonstration zone. There are 4 little slivers of sidewalks on the eastern front, 2 in front of the House and Senate, and then 2 sort of in the middle. And then as the sidewalks wrap around the south and north, those are not yellow. Those are in a no demonstration zone. So Lederman in 2001 said the eastern front sidewalk is a traditional public forum. The board, after that case, issued this demonstration map that had the sidewalks in the no demonstration zone. So, I don't know what the government says in its brief that it doesn't enforce the no demonstration zone around those sidewalks. I don't remember which of your honors said it, but that's a problem of discretion. The document allows prosecution for being in that area, and the government in its discretion is saying, well, we're not going to prosecute that. I would encourage your honors to look at Lederman. The analysis there is exactly what we're asking the court to do in the context of narrow tailoring. This is a near total ban. It's an under-inclusive ban insofar as it allows tourists, joggers, dog walkers, whatever, and it allows members of Congress to go out there. And then there are many less restrictive means, just like in Lederman, permit. The board can impose a permit requirement. The board can impose durational limitations. The board can impose group size limitations. I heard the government attorney say a number of times that, well, members of Congress are different because they typically announce that they're going to demonstrate. Well, the board could require that of the rest of us. I mean, the board could impose a requirement that the demonstration be announced. The board could impose a permit requirement as it does elsewhere on the Capitol grounds.
So your challenge, and you say this will be confirmed in 446, JA 446, is not only the 7 eastern steps, but the sidewalks and the base.
Yes, Your Honor, and I'm happy to point this out in a picture, but the Senate and the House steps are almost identical.
Right.
I'll talk about them first.
Right.
They have a raised sidewalk up from the plaza
Right.
around all 3 sides, north, south, and east, and then they go up into the steps. So the area in question is all 3 sidewalks and the steps. In Lederman, this court already held that the sidewalk immediately east of the steps is a traditional public forum. So that's not really in
It
dispute.
didn't have the steps before it. And I think it's fascinating everybody avoids the case where we were dealing with the eastern steps, which I thought was what this case is about. But in any event, so you're saying that any of the steps, any of the sidewalk, and any of the bases
So the road,
associated with the Capitol building are a traditional First Amendment
yes, Your Honor.
forum.
The center steps or the rotunda steps, if we've called them, they're different in that they don't have a little raised base, but it's a plaza. So like Frisbee, it's a street. It's also a traditional public forum. And to be clear, I'm in agreement with Your Honor that Dellums decides this case. I mean, Dellums cited Nicholson. Nicholson very clearly held that the area in question is a traditional public forum. I think this court is bound by it. But there are, in addition to that, reason upon reason, precedent upon precedent, why the steps are a
So
traditional
if
public
you were
forum.
to prevail 100% on your claim, all the Capitol steps would be a traditional First Amendment forum.
Up to the bear.
No, Your Honor. The way this
Tell
step,
me what you're excluding, because these maps, it wasn't
Yeah.
as clear to me exactly what the district court was focusing on, much less what you were seeking.
there are on the Senate and House,
Right.
approximately 7 steps to a little landing, then approximately 10 more steps to another little landing where there are barricades. We are seeking the sidewalk around the steps up to the barricade. In the rotunda, it's a little bit different. Again, there's not sidewalks at the base. There's just a plaza. There are 7 steps and then the barricade. So we're seeking up to the barricades in those steps as well.
Streets plus 7 steps
In the center, yes.
everywhere. Center, the east, and the west.
Again, there's a little bit different configuration. There's 18 steps on the House and Senate side,
Right.
and then 7 in the center.
So the center are the only 7 steps that are addressed here.
There are only 7 that are addressed. There are, I don't remember how many above the steps to the plaza at the top, but we're not seeking a ruling with respect to those steps, nor are we seeking ruling with respect to any steps on the western side or frankly anywhere else. It's just these 3 sets of stairs on the eastern front.
In what you're describing as the rotunda
In the center.
area.
In the center. Yes, Your Honor. And then, of course, House and Senate as well, those 3 sets of steps.
Can I ask you how you define vigil?
The
Dictionary says it's a watch. And I think I led my clerks on a merry-go-round about whether silent vigil is redundant.
that term is used in the,
As I understand the record, Reverend Mahoney, along with either his family or a few people, and I know it's not just limited to this, but wants to stand silently before Christmas, before Easter, and actually the dictionary says that was the time in religious terms that a vigil was held on the eve of a religious holiday.
the demonstration activity that formed the basis of the claim here was a gathering with Reverend Mahoney, his wife, 3 or 4 other people holding a sign that advocates for a position. That's exactly what he was doing when he was arrested on August 12th, give or take, of 2021. So that's what forms the basis of the demonstration activity here. It's holding a sign, advocating for a cause.
Okay, I just think that vigil is different from protest, rally, march, gathering, particularly since this also includes a one-person vigil.
I mean, I would interpret the word vigil to mean a religious leader praying quietly.
But wouldn't have to be a religious leader.
No, of course not. I'm sorry, Your Honor, but it would include that. And my client is a religious leader, so I would, yes, that's right.
Praying out loud. I just want to be clear. I think that Henderson's question at least implied to me that she was distinguishing between a silent vigil, just bodies present, and a speaking vigil, if I can put it that way.
I mean, I think that a silent vigil can be communicative. If we're getting at the question of whether it's protected by the First Amendment, a silent vigil can be communicative. You are gathering with others and you are have spoken with the others about what the purpose of the gathering. That could be communicative, even if the prayer to God itself is not out loud.
Right.
But that's why I said in my answer that it would include a religious leader quietly praying.
My only point is that what goes on the Capitol grounds does not preclude announcements before the vigil or whatever
Exactly, Your Honor.
on the Capitol grounds as to why I am going to be there Monday through Friday from 10 to noon.
Exactly, Your Honor. Your Honors, may I speak to the remedy?
All right.
The district court here enjoined the board from enforcing the no demonstration zone in full as to the world.
But that's been stayed. Didn't he stay it?
I'm sorry, Your Honor.
Didn't he stay?
He did say that. He did say that pending appeal. But that's what the injunction, scope of the injunction is. The board in its summary judgment briefing did not oppose our request for universal relief. So the board has forfeit any argument that it has that
Well,
universal.
it goes to jurisdiction though, doesn't it?
The government does make an Article 3 argument, Your Honor, and I do think that would not be barred by this principle. But the Supreme Court, neither this court nor the Supreme Court has ever held that a universal injunction is a jurisdictional question. In CASA, the Supreme Court held that the Judiciary Act of 1789 didn't authorize courts to enter universal relief, but it specifically reserved the question of whether Article 3 allows for universal relief. And I would submit that this court's decision in the national mining case, which authorizes vacator as the proper remedy under the APA, necessarily means that universal relief is permissible under Article 3. If it weren't the case, then the APA would be unconstitutional. It could only enter relief as to the parties in an APA claim as well. So this court has already held that universal relief is not an Article 3 problem. So that, now we're back to waiver where the government has argued, or forfeiture, where the government has argued that the injunction is manifestly unjust, and that argument I would submit has been forfeit. In addition, they can't raise an argument for the first time in reconsideration, which is what they did.
Well, what about the Supreme Court decision?
Explain. I'm sorry, Your Honor.
Forfeiture applies when there is no explanation given for not raising an issue of which you were aware and had the opportunity to present. Now we have a Supreme Court decision. The district court hasn't said anything about it.
That is true. The government, however, argued lack of manifest or presence of manifest injustice even prior to the CASA case coming out. This is an argument they've been making around the country. They just, even before CASA, they just didn't make it in our case. So we believe it's forfeit. I would also point out that this is a First Amendment case. CASA was a case about the birthright citizenship clause. The Supreme Court has long held, since the 1940s, that facial relief is uniquely appropriate in the First Amendment context, not to benefit the parties, but to benefit society. And that language comes from the Munson case. So while the Supreme Court held in CASA that the Judiciary Act of 1789 doesn't authorize universal relief, the First Amendment was enacted in 1791. And the Supreme Court has held 50, 60 more years that facial relief is uniquely proper in the First Amendment context because of the unique importance of speech in our constitutional design. I would also point out that in a pre-CASA case called Griffith against HM Florida, this same issue that was presented in CASA was brought to the Supreme Court, and the Supreme Court denied cert. Alito, Thomas, and Gorsuch would have voted to grant cert. Kavanaugh and Barrett wrote a separate opinion respecting why they denied cert. And what Justice Kavanaugh said was, this is not the proper vehicle for this case precisely because the First Amendment presents, quote, doctrinal complexities that make this a difficult case to decide. And so I would submit, Your Honor, that even if you're in the business of counting noses, we don't have 5 noses for this being CASA being a holding that extends to the First Amendment.
And you don't think Justice Kavanaugh's point about complexity applies?
I'm sorry, Your Honor?
You do not think Justice Kavanaugh's point about complexity applies here?
I think it absolutely applies here. I think because of the doctrinal complexities of the First Amendment, namely, we have granted standing exceptions under the overbreadth doctrine.
And you think this court should just go ahead and decide it, not remand it for the district court to examine the question in light of.
I believe this court can decide that question, Your Honor.
And question is, should it?
I think the issue has been fully vetted, and this court can, we would take either, but we believe that this court can consider the question afresh.
All right, thank you.
Thank you, Your Honors.
Okay. How about 2 minutes?
Thank you, Your Honors. I'd just like to address a few points in my limited time. First of all, I'd like to return to Judge Rao's question about there being a line drawing problem. I do think that plaintiff has a line drawing problem here. The only distinction that plaintiff draws between the lower halves of the steps and the upper half of the steps is that there's a barricade. That barricade has no talismanic significance. The board has, allowed the public out of its own grace to use the bottom steps. And I think this court's cases, including Hodge and Oberwetter, are very clear. You're not supposed to penalize the government for opening property to the public. That doesn't create a First Amendment problem.
As a matter of grace?
Your Honor, this is
Your words, not mine.
Your Honor, this is the government's property, and it has opened it up to the public to have access to, go onto the property, but that doesn't mean it's opening it up for demonstration activities. That's the trade-off that the board has, allowed to happen here, and I think that's supported by this court's cases. I would also point out, as my second point, that both Hodge and Oberwetter's the case about the Jefferson Memorial, discuss situations where the government there allowed certain speech, circumscribed speech in the non-public forum, and that didn't create a problem of reasonableness.
Such a different context.
Your Honor, I don't think that it is a different context. I think.
Well, it has nothing to do with legislating. It has nothing to do with commemoration, small memorial. I mean, it's magnificent, but it's small in size.
Your Honor, but the government would hold its own events there. And as Hodge discussed in the Supreme Court Plaza case, it would sometimes allow attorneys to speak on the steps, even though as a general matter, that expressive activity was not allowed by the public. The last just quick point I would like to make is I think the other side identified certain alternatives that, plaintiff thinks are appropriate here. I would just point the court to the Supreme Court's recent decision in Free Speech Coalition v. Paxton, which was about Texas's aid age verification law. And there, the Supreme Court reiterated the principles. Again, this is assuming we're applying intermediate scrutiny, that even if there are other alternatives that have been identified that are equally or more effective, as long as the restriction at issue directly advances the government's interests and that the interests would be less well served without the restriction, it should be upheld under intermediate scrutiny. Your Honors, unless there are any other questions, we would ask that this court reverse.
All right, thank you.
Thank you, Your Honors.
Stand. This honorable court now stands adjourned until Friday, October 10th at 9:30 a.m.